Number 196, the matter of Turturro versus the City of New York. Counsel?
Your Honor, may it please the court, Susan Greenberg for appellant, the City of New York. 3 minutes for rebuttal, please.
Certainly.
Your Honors, at bottom, this lawsuit seeks to hold government liable for not stopping a driver's refusal to follow the rules of the road. That's a theory of liability that's never been recognized by this court, that has broad ramifications for municipal liability, and that is, on this record, impermissibly speculative.
So in this case, we have someone that pleaded guilty to a crime, right? And
Correct, Your Honor.
Okay. So what about in a different case where that didn't happen? So are you saying that the government, that the city is not responsible for maintaining its roads in a reasonably safe condition for pedestrians or bicycle riders?
What we're saying is that the tort duty extends to ensuring that a roadway is reasonably safe, presuming that drivers and pedestrians obey binding controls, and that.
So is it limited only to people who have obeyed the law? What are those who don't obey the law? What if I'm going 40 miles an hour on a 30-mile-an-hour road? The city has no responsibility for design or maintenance?
Your Honor, certainly the city has a responsibility, but we're saying that's a public duty that runs to the public at large. The city has a responsibility.
Well, slow down. The public duty runs to the public at large, but you have no responsibility to the people that use the road legally.
Not a tort duty, but we're saying also, certainly that is true, but we're also saying that this is such an extreme case that the court doesn't even need to reach that issue. Here, the driver, Pascarella, pled guilty to a felony assault. That's not even a driving-specific crime. And the city has a responsibility to prevent that type of crime, not just on 6,000 miles of road, but on the sidewalks, in the subway tunnels, in people's houses, in the piers. And this court has recognized over and over again that society is best served when public employees decide how to best protect the public.
Okay, so in this case, when public employees were asked to look at the situation because there had been so many complaints about speeding on this, what essentially appears to me to be a straightway, and the city undertook some studies but didn't actually apparently look at the speeding issue itself, the city has no responsibility?
Just to clarify on that point, and then I'll return to the question about duty. The studies that the city did were not studies of speeding along the length of a roadway. They were studies that were responsive to complaints about speeding on the length of the roadway.
But isn't that the issue, whether it was responsive to the complaints?
The trial evidence showed very clearly that it was for 4 key reasons, Your Honor. First of all, first and foremost, the reason that the community is requesting traffic lights and that the Department of Transportation is studying whether to provide them is because traffic lights provide pedestrians and bicyclists a safe place to cross. So the fact that a car...
Well, but that's the point here, is that the complaints were about speeding. And if they thought that the answer to that was traffic lights, but it turns out that that's not the answer to speeding, does that end the city's duty to...
The city referred it for policing and for police enforcement.
And the complaints continued, right?
And they studied it again. So the trial evidence
But
was
you're not contesting it. It seems like all the experts agree, at least at trial, that there was, the traffic studies weren't done.
I'm sorry.
The traffic studies weren't done.
There
were 4 studies done by ICU, and they did not address the problem.
Certainly, Your Honor, we're saying that the evidence shows that they were a rational response to the problem, and that's exactly what I'm getting at. So the fact that a car may speed up in between the lights does not mean that a traffic light is not responsive to the complaints about
Well,
speeding.
it's not just a traffic light. I think the whole, what should be done is a whole separate question. But the fact that the study itself wasn't done, at least at the trial level, seems to be pretty conclusive.
The evidence was the city chose to conduct one study and not a different type of study. Bear in mind also, of the 14 letters, 12 of those 14 specifically dealt with the area by the school, and many of them raised questions and concerns about school crossing, and the intersection control unit is the only unit that decides whether to put in a school crossing. Similarly, there were concerns, right, about traffic accidents. You've got the bisecting side streets in northern Garrettson Avenue, and so a traffic light prevents a dangerous right
But the
angle.
city can't say it's not aware from those complaints that there is a speeding problem, there is a drag racing problem, that this is, as we often hear on the news, right, one of these boulevards of death, that there's really a problem on this particular road.
But
And so,
spe-
and let me finish.
Sorry.
So if your response is, well, when there's a speeding problem, the answer to that is the police have to stop them and give tickets, that hasn't worked. So is the city's position that regardless of whether or not the law enforcement protocols don't work, you can stand back and do nothing?
No, Your Honor, what we're saying is that speeding is complex, and there are a range of approaches that you can take, and it can't be that there's a tort duty to completely prevent speeding on a public roadway.
No, but let me give you an example. Of course, I recognize the nature of your argument, but you're asking us, we have two paths to go down here. We can go down the governmental path or the proprietary path. You're proposing that we go down the governmental path. Is that
Correct.
a fair reflection of it?
And
Okay.
this court has recognized time and again that where you're dealing with an issue of policing on a complex decisions about policing in a broader public area, the fact that a municipality could supplement those efforts with some property-based measure does not make it proprietary.
Has this court ever analyzed road design or maintenance cases based on a governmental function?
Not in this way, but certainly that's the reasoning behind Bonner, Klinger, Wiener, Miller World Trade Center. The same principle applies here. I'd like, if I could, because I see I have very little time left, to turn briefly to proximate cause. Here it was undisputed that plaintiff's traffic calming theory was beyond the ken of an ordinary juror, right? Plaintiff's whole theory is that lay people don't understand about traffic calming, and that's why they're requesting traffic calming, but you really need a traffic light. So at a minimum, plaintiff's expert needed to identify a particular measure that should have been implemented. To opine that its absence was a substantial factor in causing this particular accident, and to explain why. And the reasons that he did, there are reasons that their expert was unable to do that, having to do both with the challenges of policing this particular location and traffic calming this location, and of this particular driver. The expert also completely failed to opine that any traffic calming measure that could have been implemented would have had any effect on the driving of someone like Pasquarella, right? Our expert said if somebody's irresponsible enough to go 48 to 52 in a 30-mile-per-hour zone, traffic calming's not going to
Would
stop
that
them.
person, would that driver have been able to speed on a roadway that included speed bumps? Isn't that the whole nature of speed bumps, that you have to slow down, otherwise you tear up your car and
It was-
possibly injure yourself?
It was undisputed that speed bumps would not be appropriate for this roadway. Here's the key thing. This roadway, Garrison Avenue, is the sole point of egress for that neighborhood, which makes it a very challenging place to calm, right? You can see in the evidence, it's a peninsula-shaped neighborhood. The water comes in the middle. So for the whole southern portion, you've got a neighborhood that's completely bounded by water and has one road out, right? If a storm is coming and they need to evacuate, one road out. If there's a fire trucks need to come, there's one road in. A bomb scare, a terrorist threat, one road for emergency vehicles. That's not a road where you want to put speed bumps, roundabouts, rumble strips.
But what your argument is that that your study would have shown, that if the study that wasn't done, would have, if it had been done, would have made no difference, because there is no design difference that would make a difference.
No, what I'm saying is that plaintiff's causation theory was deficient at the most basic level because he did not and could not identify a particular measure that would have been appropriate for Garrison Avenue and that would have had any effect on preventing this accident.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. My name is Robert Walker. I represent the plaintiff respondent. At counsel table with me is Michael Walker of the firm.
Counsel, could you address first what opposing counsel finished with, the approximate cause argument?
Yes, sir. Your Honor, the testimony was from the city's own expert, Mr. Summerfield, that it has been known for many decades that traffic calming is an effective means of reducing speeds, controlling speeds. Indeed, it's known to reduce the whole speed curve. The ITE manual, which is the Institute of Transportation Engineers, which all the municipalities rely on, specifically contain, there was a mention of speed bumps. It's not just speed bumps. There are literally dozens and dozens of these traffic calming
But
measures.
isn't that her point? In other words, let's assume instead of a road, we're talking about a saw.
and somebody gets hurt on a saw. And the plaintiff comes in and says, well, they could have taken the saw blade off, they could have put a guard on, they could have taken the plug out of the wall, they could have, that's not a case. You got to show, I think her argument is that you have to show that this is what caused this accident. And so if you'd put in, if your expert had said speed bumps would do it, they would counter by saying speed bumps are only used in certain situations, slow, for construction things. So that doesn't, he wants to say divided highway. I would then think the city would want to say, well, you can't divide this highway because of whatever. So does it do it to simply say, there are ways that you could have calmed the traffic here, and here's a dozen of them, therefore we win?
Your Honor, to address Your Honor's question, there was also testimony from the plaintiff's expert, Mr. Hintersteiner, who was a traffic engineer.
Well, that's what I meant. You were talking about the defense side, but I was thinking your prima facie case, he's the one that said, divide the highway, do the rumble strips, do this, do that. But he never said, I've looked at this, and now I know what we ought to be doing here, and maybe what we ought to be doing here is reducing the speed to 10 miles an hour. Then they'd come back and say you can't do that.
He did express an opinion, however, Judge, specifically on proximate cause, that traffic calming measures are the appropriate response, could have been used, and had they been used.
You missing my question? I mean, can you just say that? Can you go back to my saw case? Can you simply say, well, they could have put guards on, they could have unplugged it, they could have done that? Doesn't get you to a prima facie case, does it? I mean, you have to prove that injury, the cause, and the cause was the proximate cause, and in this case, they could have prevented that by, and you're saying everything.
Not really, Judge. I'll concede the answer to your
getting.
question as to the saw, your example, yes.
Get rid of the
I
saw.
think what's different about the case, the actual testimony, we had unrefuted testimony, actually agreeing testimony by the experts on both, that traffic calming measures are effective in reducing speed. The case involved speed, there was no question about that. Exactly what I thought was interesting, the type of speeding that was involved here is exactly why traffic calming works. The testimony from the gentleman, Mr. Pasquarella, who was ultimately convicted, he admitted that he was speeding ultimately, but his actual trial testimony was, I did not think I was going over 35 miles per hour.
It's the same one that was it 17 charges he had before that was never before the jury, and the fact that he'd been caught speeding on this road before. I mean, he's not. I didn't get the impression that he was some lamb that said, "Oh my God, I was lured into speeding here because my car is so nice."
Yeah, I'm not sure if it was 17 or not. There was a prior traffic conviction for speeding on that road that the judge
So were
let
they,
in.
not to get too far in the weeds on him, but were they charges that he had on that road?
Prior speed, no, not 17. There was one prior speeding charge on that
And
road.
I assume that's the police who charged him there, right?
Yes, he got a ticket and it was a simple-
17 suspension, license suspension.
Yeah, I think there was only
Could've been
one
on-
speeding ticket on this road, because the judge,
you're right.
Judge Kramer let that into evidence.
Could we
because
get
it might
back
be
to the
relevant.
question that your adversary raised, though, counsel, about
Yeah,
whether
sure.
you have to show as part of your prima facie case that there is a specific traffic calming measure that could have been taken here so that the city would have an opportunity to rebut that?
Your Honor, I think that the plaintiff's expert did address that. He said there was any number of things that can be done. Mr. Sommerfeld conceded on cross that, yes, there are any number of things that could be done, either individually and/or in combination, to get the specific speed. There was testimony, as a matter of fact, that what they often do with these, they'll try out things to see how they work, if they need to be spaced differently or tried differently, and go back and redo the plan. The more basic issue, I guess, was the plan was never done, so it's kind of, but I don't think proximate cause, from, if I understand the court's cases, you don't have to prove with 100% certainty that the accident would have been, that this accident would not have happened. The standard is one of more probable or not, and I think that certainly meets it. I might point out, we had testimony from, there was a biomechanical expert, Mr. Fidzikowski, that the city called, and he conceded specifically that had the speed been lower, this impact would never have occurred because the car would have stopped 28 feet before the point of impact.
So one of the reasons for proximate cause is they had a 30 mile per hour speed limit and it should have been less.
Should have been less?
Yeah.
No.
Didn't you just say that if the speed had been lower, the impact would have been less and he would not have?
No, for instance, he specifically conceded that if the car had been traveling at 35 miles per hour, for instance, which would still be over the speed limit, but the impact would not have occurred.
So your point with that is that if they had used traffic calming protocols, not necessarily a sign that says this is the speed limit, not necessarily a traffic light, but these other traffic calming protocols, that the speed would have been reduced.
Yes, Your Honor, exactly. What happens, the principle that underlies traffic calming, Mr. Sommerfeld was actually the one that gave this testimony. The image is, if you picture a very narrow winding alley that's barely wider than your car, you can put a 65 mile per hour speed limit there. Nobody's going to do that because of what's called friction. The driver's concerned about clearances and whatnot. The alternative to that is you can have a 6-lane straight highway and put a 30 mile per hour speed limit. They know, as traffic engineers, that most people aren't going to go 30 miles per hour. It's an inherent reaction of drivers, just as Mr. Stone said, he wasn't looking at speedometer, he thought he was going with
But to follow
35.
up, Judge Abdul Salam
Yes, sir.
was asking, I think, and I was too, Hintersteiner, your expert, never said what they had to do was this.
In terms of picking a specific a protocol of specific devices,
Rumble
yes, Your Honor, I would
strips,
agree with that.
You know.
Well,
But don't, I mean, how do you, okay.
yeah, I mean, I would concede that he didn't say, give a specific plan, this is what I would use. What he did say, there were a number of things that could be used.
From a technical standpoint, is it a discrete, limited universe of traffic calming protocols? Or is that up for grabs? I think that also is in part what these questions are trying to ask you.
Yeah, Judge, the IT manual contains literally dozens of different types of devices that can be used individually or in combination. There's science to this.
Yeah, I
that
thought
can
the
be
more
spaced.
fundamental issue was whether or not a study was to be done. Isn't that the source of the duty that was violated?
Yeah, exactly, Judge.
Right. And I think both experts concede that a traffic calming study was not done here.
That's right.
And the guy you were quoting before was a defense expert, Summerfield.
That's correct, Your Honor.
Yeah, that's what I thought, okay.
Oh, but the question then is the proximate cause. I think that's correct. The question is whether or not having done the study and not taking these measures results in the accident, right?
Yeah,
The proximate cause of the accident.
I understand, Judge. I think what Mr. Hintersteiner specifically did testify to and gave an opinion to, that these measures were available and could have been implemented in a way to avoid this accident. And failing to do that study and implement some of these was the proximate cause. Mr. Summerfield conceded, yes, these are known to be effective. This could have been done. Whether it was a rumple strip or not, or this,
So as I
I think is
understand your
irrelevant.
argument, you're, first of all, you're not saying that the driver didn't have also some liability here.
Of course not, Judge. We argue.
You're not saying the city was the sole proximate cause. What you're
Absolutely.
saying is that had any one or more of these identified measures, which your experts talked about, been implemented and even slowed this car down, not even necessarily below the speed limit, that there was a chance this wouldn't have happened.
And that was Mr. Fidzikowski's point, that, on cross, he conceded, even at 35 miles per hour, 5 miles still over the posted speed limit, this impact never occurs. So yes, that's exactly.
So the protocols are, in the sense that they work, is that there is no way that one could reach the speed that this car reached.
Exactly.
With some or any or combination of these protocols. That's the point of the expert.
That was
He might
specific.
still be speeding, but he couldn't have done this.
Well, exactly, Judge. Mr. Summerfeld conceded that they are known, traffic calming measures are known to be effective.
Can I ask, why isn't it appropriate for them to rely on law enforcement if we're talking about bad behavior of members of the community? Or even someone just driving through who's not from that community?
I think, Your Honor, specifically to address that, and Mr. Summerfeld, the plaintiff's expert, conceded this, one of the very indications in the ITE manual for traffic calming is if normal traffic enforcement police efforts are not effective. That's a completely separate warrant for starting a traffic.
There's a
calming study.
rumor, and I don't know if it's true or not, that there are people that drive on the New York State Thruway in excess of 65 miles an hour.
I'm shocked by
I
that.
don't know if that's true, but if it is true, and they haven't done a study, and there's an accident on the New York State Thruway, is the New York State Thruway Authority responsible for failure to test the
Absolutely not,
speeding?
Judge. Absolutely not. I think there's a big difference between the New York State Thruway and a local stretch of street where you have specific, I mean, there were a tremendous number of written complaints by virtually.
I'm suggesting, as I say, I don't know, but I drive the Thruway, and a lot of people pass me because I do 64, and I'm not under oath, but if we know that all this is happening, isn't the logical extension of that then that any accident that happens on a Thruway where someone is speeding is the responsibility, to some extent, of the New York State Thruway Authority for not doing calming studies?
I don't think there would be any such duty, Your Honor. If, in your example, you're proposing an isolated, random act of speeding,
No.
which happens,
I'm saying that everybody speeds, that's the problem, and there's accidents as a result, and the damage is worse because people are going faster, and they're on their phones and whatever, and unless and until the New York State Thruway Authority does some type of study, they are in every single lawsuit involving an accident on the Thruway, are they not?
Your Honor, to address your question, I think if there were specific complaints that a particular section of the Thruway, for whatever reason, had a high accident rate and a high speeding rate, I think that would then trigger the duty to do a study, and that's what we have here.
Well,
But I don't think just a
But if the
general.
complaints are, you need more traffic lights, and the Thruway Authority says, we don't use traffic lights. Your argument would be, well, they complained about traffic lights, but everybody knows that that's not going to work, so they should have done something else.
Yes, and for instance, I mean, I guess the analogy on a roadway like the Thruway, like a superhighway, would be if they had a turn in the road that an abnormal amount of cars were not negotiating and going off that's partly the driver's fault, obviously, but at some point it becomes, well, maybe we have to look at the design of the road. And that's what we have here, Judge, I think.
Thank you, Mr. Walker.
Thank you very much, Your Honor.
You're welcome. Ms. Greenberg?
Your Honors, if I could just speak to some of the questions about the expert testimony. The point about whether their expert said if you had done a combination of measures, he couldn't have sped. That's exactly what their expert did not say. He freely conceded and admitted that if you put in traffic calming measures, if someone chooses to speed, you're not going to stop them. And he never opined that any traffic calming measure would have prevented or had any effect on this accident. The only thing he said.
So is it true that he also didn't opine that even if you couldn't stop the speeding, that is, you're driving in excess of the speed limit, you could at least slow them down, and that might have made a difference?
He opined that traffic calming would have an effect on the average speed of reasonable drivers, right? So the parents driving their kids to school during the day on Garrettson Avenue might have a modest 5 to 15% reduction in speed. He never opined that any measure that would be appropriate for this area would in any way affect the top 15% of speeders. And this is a guy, bear in mind.
But if the point of that is because the car's got to slow down to work its way through these traffic calming designs, why isn't it, of course, a fortiori that would be true if one is driving at 70 as opposed to 40?
Because again, any of the measures that we're talking about for this roadway would not physically force a driver to slow down. There are things that increase their workload.
You don't know that because you didn't do any of the studies. Listen, everybody who worked for the city of New York said you didn't do the studies after all these complaints. Let me finish. I count at least 4. Your own expert said that the studies that were done were not traffic calming studies. Excuse me, just let me finish here now. So to say that they have to say, first you got to do the study, and then out of the study we have to say what are the appropriate measures that should be done. But the question is whether or not you had a duty to do the study, and it seems almost uncontested in terms of raw evidence that you didn't meet that duty.
To the contrary, Your Honors, the studies that we did included speed studies that complied with engineering standards and that showed that speeding while present was normal and that this was the incremental approach the city chose to take. And here's our key point about immunity. Regardless of whether this court calls it discretionary function or qualified, if it's going to fulfill the purposes for which this court developed the doctrine, it has to give public employees the latitude and discretion to make a decision, whether that's to conduct a study, not to conduct a study, study, to conduct one type of study and not to conduct another type of study.
But
And just-
that's not what happened here. You know, Patricia Mattia, the engineer at DOT, said you're not aware of any complaints or requests for a study at all. Melita James said there was no study to look at the complaints. So it wasn't like there was a choice made between to do the study or not do the study. There was no decision to do anything at all. Complaints were made and no response came
To
forward.
the contrary, Your Honor, the evidence showed that these complaints were routed to a particular unit in the first instance because it was the one that was most responsive to the range of complaints, including the issues about school crossing, including the issues about pedestrian and bicyclist safety. And can there really be any doubt that if the opposite was true, right? That if we had done traffic calming and we hadn't done a traffic light, that plaintiff would have said that this accident would have been prevented by a traffic light because it would have given Anthony Turturro
But you would have had a
safe life.
basis by which you would have said, this is why we chose one over the other, which is what I think Judge Fahey is trying to stress to you, you don't have in this record.
Our director of signals said that they chose to do this particular type of study, and then they chose to deal with this as an enforcement measure because they studied the speeding on that road over and over again, and the speeding while present was within normal
But
ranges.
that's what you always had, right? I mean, you always have enforcement, you know, it's not responding to anything. When you do what you've always done, that has not resolved the speeding issue.
But they did heightened
But I mean, it is
enforcement.
always true that you're doing enforcement. All types of vehicular law violations, right, you can deal with through enforcement. So your response that, well, we decided to just give them tickets and stop them, but that had not worked up to then.
Yeah, it's
Isn't
kind
that-
of like
isn't that what
your
the complaints
traffic
are going?
calming plan seems to be law enforcement, which is perfectly legitimate. I'm not saying that's not legitimate. It's a proper response by the city. But under that theory, then there would never be, it's kind of like what Judge Biggett was talking about, there would never be a question of highway safety or design. There would be, it's contrary to a lot of case law from this court.
To the contrary, just to be clear on the facts, right, the evidence was that the city has a policy that they study again in 18 months, and that's what they did here. They did study it again. And because this is a case that's going to affect a lot of other cases, I might as well say it's a matter of public record. The city is still studying whether to put traffic lights on Garrettson Avenue. Did a most recent study this year for the first time. It met the criteria. And the city intends to put a traffic light at Channel and Garrettson to address the problem of speeding along the entire length of the roadway. So it's not that we're saying that we don't have a duty, but we're saying this duty is first and foremost a law enforcement function. To the extent that traffic calming is used as a supplement, you can't get away from the fact that that's mixed up with looking at the reasonableness of our enforcement, the effectiveness of our
Why
enforcement.
can't we look at it the opposite way? Like traffic calming is the main duty and enforcement is the supplementary.
The trial evidence was just the opposite. Even their expert conceded that stopping speeding in general, leaving aside the question of how you would stop this particular driver or the drag racing that the letters were talking about, but even regular speeding is first and foremost a police matter. Their expert agreed with that and said you try policing first. And that's why throughout this trial, plaintiff at every single critical
But that was
point-
my point. Isn't that what you were doing to begin with? Now, I could see if your argument is, we'd always, of course, we do enforcement throughout the city, we were doing enforcement on Garrettson, we needed to consider whether or not a different type of enforcement was the better response. But did you do that?
So again, to
But did you
defend-
study that? Is there something in the record that shows that?
The record shows that we did do a second set of studies 18 months later. Those included speed studies. Those included studies of various measures on this roadway. And there's no way, the basic point is this, there's no way that the city could defend itself against that claim without putting on a defense that dealt with much broader questions about how we allocate police enforcement resources, about how we scaled up the effectiveness of our police enforcement. And that's exactly the outcome that the public duty bar is designed to prevent, right? In closing arguments, plaintiff's counsel said, the city refers things to law enforcement, they close the folder and they put it away, right? And there's no way for us to defend ourselves against that claim and avoid the type of liability that was imposed here without putting our law enforcement efforts on trial and explaining what heightened efforts we do, how we choose to allocate public safety resources across the competing needs around the city.
Thank you, Ms. Greenberg.
Thank you, Your Honor.